Well, the big local news today, two former Minneapolis police officers sentenced to federal prison after being convicted of depriving George Floyd's civil rights on the day he was murdered. Thao will serve 3.5 years and J. Alexander Kueng will serve 3 years in federal custody. Both men scheduled to report for their prison terms the first week of October. But their criminal trial, where they face state charges of aiding and abetting second-degree murder and manslaughter, is supposed to be held a few weeks after that. So to answer the first big question tonight is the one many have had before. Our friend and legal analyst A.L. Brown is here. Mr. Brown, in your expert opinion, will the state trial actually happen for Thao and Kueng, or will they make a plea?
Well, in my expert opinion, I don't know. It's a conversation that's likely taking place between their counsel and the state. I think it's time to make an agreement. I don't quite see the point of going to trial in the state court case. The stakes are so much higher than they are in the federal case. They're exposed to the same type of sentence that Derek Chauvin got. And so 3.5 years, 3 years looks pretty light compared to the 20 some odd years they could potentially face in state court. That's a big risk to take, given that they've lost all the trials thus far.
Right, and we're now 2+ years removed from the murder of George Floyd. And I want to ask you about the cost of this trial. I often hear it talked about, let's not have this last trial. It's going to cost a lot of money. But there's a community emotional cost. There is a family cost. There is a cost to the witnesses too, right?
Yep, that's true. But every defendant is entitled to a trial, and we don't decide whether people go to trial by how much it costs the state. That's the state's problem. They decided to try them, and so they have to bear the cost of it. But there is that toll on the family that might encourage the state to make a deal that would induce them into a resolution short of trial. Having to testify again, having to pull the officers off of the beat in order to testify, some of which might have retired by now. The difficulty of contacting witnesses. The risk to the state is, in fact, that, some of the passions, as naturally would occur, have quailed a bit. And the state risks the possibility that one juror may decide that they're not guilty, and that would be sufficient for a hung jury, and then the state would have to decide whether they're going to try them again. So there's cost on both ends, but the financial cost, that's the state's problem. We don't count that into the analysis. But what the defendants should be considering, the former officers, is do they want to take the risk and go into prison for such a significant period of time?
And that's the conversation I assume they each have, Mr. Thao and Mr. Kueng, with their attorneys. Their attorneys explain to them, we've seen how this went in the federal trial. Derek Chauvin was convicted. Do you want to take the chance, or do you want to take the plea? Attorneys
explain, attorneys advise, clients decide. That's the way it goes when it comes to a criminal trial. You can tell the client, no way you should go to trial. You'll be convicted right after lunch. Or you should absolutely go to trial. They don't have you. At the end of the day, it is the client's decision.
All right, and we just have about 30 seconds left, and you and I were just talking about this. You think if they are offered a plea, it might be happening as we speak, pretty quick, and they'll get not a lot of time to think about it, right?
If I were in Keith Ellison's shoes, and I am not, I'd give them a plea, tell them they have 48 hours to think about it, and I'd make it the type of plea they'd be inclined to take.
All right, A.L. Brown, thank you for being on the show. We always appreciate it.
Thank you.